All rise. The Court of Appeals Division 1 is now in session.
Good morning. You may be seated. Okay, we are here this morning on our case number 1CACV160060 and 0474, Jordan versus Hubbard. Counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount of time that you have remaining, including what you might have decided to reserve. We record these proceedings, so when you approach the podium, we'd be grateful if you would give us your name and the name of your client. We've read the briefs and studied at some length the record and the documents in the record. And we've also discussed the case in our conference. So with that, you may proceed.
Good morning. My name is Scott F. Gibson, and I'm here on behalf of the proposed intervener, Rick Durfee. And with me is my co-counsel, Brad Weech, who is here on behalf of Mr. Hubbard. We intend to reserve 3 minutes, and we'll do our best to do that. This case centers on a grantor's ability and power to grant authority to a trust protector to fulfill her wishes, and on the court's and arbitrators' corresponding obligation to honor and give meaning to that grant of authority. There's some other issues that are raised in there dealing with mootness and with the intervention. I'm prepared to address those if you have questions regarding those, but I would prefer to focus my time on the primary argument here.
Let me see if this might even derail that a little bit, just because if this were a trust without an ADR provision and if the addendum weren't in this case, I would totally go down the pathway you're trying to take us. But I don't see it given the trust ADR provision in the addendum. It seems like this takes it strictly into the arbitration realm.
It does, but the ADR provision must be interpreted as part of the overall incorporated trust.
But the trust protector didn't purport to vitiate any provisions of the ADR terms of the trust or the addendum.
No, but that is part of the trust, so that it has to be interpreted as part of the integrated trust.
But counsel, isn't our review of an arbitrator's award, pretty substantially limited by case law at least? And the arbitrator's ruling is binding, from my reading of the law, unless that arbitrator has gone beyond the scope of the submission. So to Judge Downey's point, aren't we, unless there's a beyond the scope of submission argument that you can make to us today that's availing, aren't we pretty much, for lack of a better word, kind of left with what the arbitrator did?
I would agree with that if we were looking at this under traditional arbitration law. But this is an issue of first impression, both in Arizona and throughout the country, in terms of what are the rights and responsibilities of a trust protector, and how does he exercise those rights and responsibilities. This particular agreement, trust agreement, gives him the authority to amend the trust at any time. And as we've seen in the Manassan case out of Florida, that's been allowed even in situations where there is litigation pending and there's been a ruling that's been made contrary to the interest of what the trust protector then comes in and amends the trust. So clearly, under the agreement, Mr. Durfee had the authority to amend the trust at any time, consistent with what Grace granted him in authority.
Well, who was that issue was presented to the arbitrator, Mr. Lassiter,
and he disregarded it.
and as in he made a legal ruling or concluded that the trust empowered him to disregard it, or put differently, that Mr. Durfee did not have the transcendent powers that he asserted he did, at least to be able to exercise them at the time. The Superior Court judge confirmed Mr. Lassiter's ruling to that effect. What in the Revised Uniform Arbitration Act empowers us to examine the correctness of that legal ruling by Mr. Lassiter?
I think it's the interplay where you have to harmonize both the Arbitration Act with the Trust Protector Act, which gives the Trust Protector the authority to do whatever he is granted the right to do by the grantor. And in this case, Grace set up a methodology whereby he could contest the decisions. And he did so under the arbitration, under the ADR provision, which is why he submitted this to a second arbitration. The interplay between these two statutes is what needs to be harmonized. Actually, it's the harmonization of three different points, both the powers that Grace granted the Trust Protector contractually. Number two would be the authority granted or recognized, I should say, under the statute. And then the third is, how does that interplay with the Arbitration Act? We've cited in our briefs a number of instances where parties are left with the ability to interpret to resolve their arbitration disputes however they agree. Part of that agreement includes the Trust Protector provisions, where he is given authority to review decisions or to amend the trust at any time.
Yeah, now you started down a road which might have been different. I mean, the trust didn't give the Trust Protector the right to review decisions of the arbitrator.
It does not
expressly.
It does not say in words of one syllable he has the right
or
to.
Or in any words.
Correct. What it says is he has the right to modify. Let me get the quote correct. He has sole discretion to delete, alter, amend, change, add to, or subtract from the trust at any time.
And when specifically did the Trust Protector change, alter, delete, amend, or add to the trust? What can you point to in the record that change occurred?
That was done effective January 1st of 2015, I believe. And that's appendix exhibit number 5. And so the question is, how do those overlay? Now, what gets ignored in a lot of this here is that under the ADR procedures, the Trust Protector is granted the authority to issue the binding interpretation, which was done before litigation was commenced here. The binding arbitration.
What litigation? You mean before the original Barbara State lawsuit was filed?
Yes. So the binding interpretation was given in this case
The March 09 letter.
In March 09, and then the litigation, which later became the arbitration, was filed several months later. And so that binding arbitration outlined specifically the holdings that were ultimately reached at the end of this matter here.
What do we make of the language in the trust to the effect, and maybe it was in the integrity agreement, I'm sorry, that once discomfort has developed between the parties, no party may, quote, substantially disturb the status quo, end quote, until the outcome of the ADR is final. I mean, doesn't that tend to show us that, to the extent that we would review the Lassiter decision on this point, Lassiter didn't err by finding that ADR, that Grace would have intended that ADR continue unimpeded by exercise of the trust protector's power.
Well, I think, number one, the notice of discomfort is the preliminary stages, and then we get into the arbitration and later phases there. I don't believe that puts a restriction on the trust protector from doing what Grace has directed him to do, which is to make sure that her intent is followed, which was done in the binding interpretation prior to litigation beginning. The statute is clear that a trust protector has whatever authority that he is granted by the grantor, and that's what Grace intended here. Both the arbitrator and the court interpreting that is bound to give meaning to what was designated in that regard. And all those provisions need to be harmonized. The provisions from the trust protector and the ADR provisions need to be harmonized together so that we determine exactly, we get the result, what Grace intended at the end of the day. What we're left with now is 180 degrees opposite of what Grace intended. How do we know that? We know that from the trust protector who met with Grace, who discussed these issues with Grace, who understood what her authority was.
We have that the trust protector discussed with Grace what would happen if there were 5.5 months of delay after her passing before the distribution could be made to Barbara, and delays, refusals to accelerate hearings would result in her death before the distribution could be made.
If you look in the schedule of the special beneficiaries, there's a statement here that Grace must be living at the time of the distribution. You then harmonize that in with the special beneficiary provisions of Section 2.11, which talk about the special beneficiary trust. Grace was not a regular beneficiary. She was a special beneficiary of the trust.
Barbara.
I'm sorry, Barbara. Thank you. And Section 2.11 references the special beneficiary trust is a subtrust established to permit discretionary distributions. So Barbara never had a right to any distributions at any time. They were limited per Grace's intent only if if Barbara received that distribution in her lifetime. I see we're coming up on our time limit here. Let me turn a few moments over to Mr. Weech unless there's a question that I can answer.
Oh, no, that's fine.
Thank you.
Good morning. Brad Weech for James Hubbard, the trustee and a beneficiary under the trust. And I'm only going to use about 3 minutes because we're going to retain the remainder for rebuttal. So I was going to cut my comments short, and I'm going to cut them even shorter. And this is where I'm going to start. As we put in our opening brief and also in our reply brief, we repeat it again, this case should have begun and ended with Arizona trust law that was codified into legislation in 2000, effective January 1 of 2009, with the trust and with the trust protector's binding interpretation. I'll make a comparison here. And I want to emphasize that this court has the responsibility to enforce the legislation that exists on all fronts. And that has to do with the balancing, or how do we make all of these parts fit together. So the legislature comes out in 2008, effective 2009, and says, you know what, we've got all these beneficiaries that are suing the grantors or the trustors, even sometimes when they're still living. We're going to do something about this. We're going to give those grantors the right to do this, 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 and this. In fact, pretty much everything they want to, with the bounty of their benevolence, because they're giving of what they've obtained in this life to someone else for nothing. Now, what is difficult, and I would think it was probably disturbing for the trial court and was disturbing for the arbitrator, is that this vision of alternate dispute resolution procedures. And procedures is what is used in the statute. And notably in the responses in the answering brief, there is no discussion about 12-10818, no discussion about ARS 12-10205. The 818 is the one that says you can have a trust protector, you can do these things. That grantor can give that trust protector the rights to make decisions on her behalf when she's unable to do that, when she's either incompetent, for example, or she's passed away. There's nothing in there that says that that trust protector has to have had discussions, commenting on a question that was asked, that that trust protector had to have discussions with the grantor about any and every possibility that might happen afterwards. No, that trust protector is put in there by legislation and given the right to make those decisions as though the grantor was still present.
Then what's the purpose of the ADR provisions? It seems like your interpretation renders the ADR requirements in the trust and the addendum completely meaningless.
The trial court asked the same question, and it's a valid question, but it's easily answered for a couple of reasons. One, the trust requires it. Now, I'll give you some comparisons. When you have a foreign judgment that is brought into this state and presented to our courts, it has to go before our court to become a judgment, doesn't it? Then what is that court allowed to do? It's restricted in what it's allowed to do by whatever the other court in another state did. Another example would be a motion for summary judgment. If there's no question of fact, then why have to file the motion for summary judgment? I mean, these are, but to get more direct to your question, Grace required it in her trust. That didn't mean Grace took away from the trust protector his right to issue a binding interpretation, but just like in a motion for summary judgment or a foreign judgment being domesticated, when it comes to our trial court and on appeal here or whatnot, our court judicial system is bound by that, is bound by whatever that determination was. They can't just ignore it. And if they do ignore it, it is outside the scope of the authority. It's outside. It is a violation. These can be these two issues of arbitration law and resolution dispute procedures can be resolved because the statutes can be intertwined. Now, I'm out of time, and I need to leave that for rebuttal unless the court would have me stay. Okay, my parting comment then is that, yes, because this is something new, the trial court and the arbitrator both would not accept the fact that they were not the person designated to interpret the trust. Thank you.
Thank you.
Your Honors, may it please the Court, I am Dan Wilson. I have the pleasure of being here today and the privilege of being here today representing my client, Marla Jordan, as personal representative of the estate, Barbara Mary Middleton. I didn't come here today with a prepared opening presentation or a short summary of what this case is about for the past 7+ years. You've got all the paperwork before you. You've got the briefs, you've got the record. The trials and tribulations that my client have gone through to get to where they are today are more than aptly set forth in all the documentation you have for review. I'd like to start out by addressing some of the arguments initially raised by Mr. Gibson. He quoted to you the Manassian case. an out-of-state case, a Florida case, as support for his view that a trust protector appointed under a trust document can essentially do anything they want, anytime they want, and it's beyond the scope of any judicial review. It usurps the power of any arbitrator. When you look at the Manassian case, there's two very different situations we had before this court than what were in Manassian. First of all, in Manassian, the trust protectors that was involved in that case had no issues regarding his or her neutrality. In this situation, the trust protector we're talking about here, the trust protector who made these after the fact, after the arbitrator's decision, after the confirmation of the arbitration award, made the decision to turn everything all around to call King's X. Mr. Durfee in this situation is Mr. Hubbard's former attorney. And by Mr. Durfee's omnipotence, as he claims, by his dictates that every arbitrator, every court must follow by his dictates, the person that benefits with this gift is not the person that Grace wanted to benefit. It's not Mary Middleton. It's not Mary Middleton's estate. It's Mr. Hubbard, Durfee's former client. There's another difference between the Manassian case. There was no discussion in that case of any Florida statute that's similar to the one you find in Arizona. And we're talking about ARS section 14-10105, particularly subpart B. And it starts out by saying the terms of a trust prevail over any provision of this chapter except. Exception number 2 is the duty of a trustee to act in good faith and in accordance with the purposes of the trust. So what that statute says is, irregardless of what a trustee may decide in respect to a trust, what a trust protector may decide in respect to a trustee's good faith, that's not binding on the court. Whatever a trust protector may decide is to, in respect to whether a trustee acts in accordance with the purposes of the trust. That's not a trust protector's sole power. That's reserved to a court, or it's reserved to an arbitrator if the matter is referred to arbitration. Subpart 12 of that statute said what's also reserved to a court or reserved to an arbitrator is the power of the court to take action consistent with the settlor's intent and exercise jurisdiction as may be necessary in the interests of justice. Again, what this says, it's not the trust protector out there who has ultimate authority on making any decision anytime. It's the court, or in this situation, it is the arbitrator, Mr. Laster, who these very issues were presented to Mr. Laster under Mr. Hubbard's agreement, his agreement that was going to bind him and was going to bind the trust, that Mr. Lassiter's decision was going to be a final and legally binding decision. The argument that was raised that back in March of 2009, there was a binding interpretation issued by Mr. Durfee. That binding interpretation was issued at a time when Mr. Durfee was acting as counsel for Mr. Hubbard. Through their briefs, they say that that was a binding interpretation issued by the trust protector. Well, when you actually look at that letter in the record, it's not from a trust protector. They reference some other provisions of the trust called dealing with trust advisors. But anyway, it's not a binding interpretation. For one reason, it was issued by Mr. Durfee while he was counsel for Mr. Hubbard in a plain conflict situation. And second, it's not binding on this court because this court, under the statute I just read to you, has reserved to it the power, just like the arbitrator, when it was put in the trial court's position, had reserved the power to make sure a trustee acts in good faith and in accordance with the purposes of the trust, to make sure that actions are taken consistent with the settlor's intent and are consistent in assuring that the interests of justice are served.
What in your view, is the intersection or the relationship between an ADR provision in a trust like this and the powers of a trust protector. When may a trust protector come in and change or clarify the language of a trust to alter the outcome of a dispute?
Well, there's some
Dictate the
guidance
outcome.
that is given in the exact trust terms, and if you allow me, I'll go get the trust terms to talk to you about it. In the trust, which is appendix item number 1 to Mr. Durfee's opening brief, the trust protector's powers are addressed starting at page 74 in section 10 regarding trust protectors. And it says the purpose of the trust protector's power to alter the trust. The purpose of granting the protector the power to alter the trust is to avoid harm to grantors and to avoid harm to the trust beneficiaries when later enacted laws, interpretation of laws, situations cause the language of the various paragraphs or provisions of the trust to frustrate the purposes of the trust or the intended tax effect of the trust. It doesn't say anything in there about the trust protector has the power to come in and amend a trust for the sole purpose of negating an arbitration award that the parties agreed was going to be final and legally binding just for the sole purpose so that money would go to the trust protector's former client. And I emphasize this integrity agreement addendum that Mr. Hubbard entered into with my client in order to get these issues resolved, the issues regarding whether my client's mother was a beneficiary, whether that gift vested in her, the issues that ultimately came before the arbitrator of whether the trust protector had the power that he asserted that he could do anything he wanted to anytime, and he could tell Mr. Laster, the arbitrator, exactly what he wanted to do. In that agreement, Mr. Hubbard bound himself and he bound his trust that Mr. Laster's award was going to be final and legally binding. So when you have Mr. Hubbard making that agreement with my client to proceed with this arbitration process before an arbitrator that Mr. Hubbard's attorney chose, then there is no sense of justice, no sense of equity in allowing the parties to go through that, to expend all the money, the time, expense, and effort, with the understanding that at the end of the game, when Mr. Laster entered his award, it was going to be final and legally binding, but then allow Mr. Hubbard through Mr. Durfee to say, no, King's X. I see where things are going. I see the arbitrator's decision. He's ruled against me and he's ruled against my former client. So King's X, I'm going to come in and I'm going to just take out the provision of the trust that gifted $200,000 to Barbara.
But he didn't do it at that point. He did it in the March 25th, 2009 letter. That is the binding interpretation. I mean, that's what the letter says. It says, this constitutes a binding interpretation of the trust. Barbara's estate is not a beneficiary of the trust, has no right to any information concerning the trust, is expressly barred from receiving any amount of the trust, and has no enforceable interest of any kind or nature in or to the trust. That was done well before the ADR.
That letter was issued. Letter was issued well before the ADR. But the parties went into the ADR with the agreement is going to be a final and legally binding determination, and they put that issue before the arbitrator of whether that was actually a binding interpretation under the authority that's reserved to the court and was reserved to the arbitrator under the statute I read to you, to make sure that the trustee acted in good faith, to make sure the purposes of the trust were followed, to make sure that the settlor's intent was followed, to make sure that the interests of justice were served. So that issue was presented to the arbitrator. Was it binding? The arbitrator said no, and that was a final and legally binding arbitration.
But doesn't that conflict with the powers given to a trust arbitrator or trust protector under ARS 14-10818B2?
No, because the statute I cited to you says, irregardless of what the terms of a trust say, there are certain issues that are reserved for the court. And those issues, again, involve whether a trustee acts in good faith in accordance with the purpose of the trust, whether a settlor's intent is being followed, and whether the interests of justice are being served.
So you contend that provision allows the court, and by extension, where the parties have agreed, the arbitrator, to determine the trustor's intent, taking into account what the trust protector may have said, but not bound by what the trust protector may have said.
Correct. It was before the arbitrator. The issue was, as presented by Mr. Hubbard in his last-minute motion filed before the arbitrator, and adopting all these things that the trust protector had told Mr. Laster, ex parte before that, he presented that issue to the arbitrator. Is the trust protector's decision the ultimate authority? Is it binding on you, or is it not? Or do you have the power in your role as the private arbitrator for this under the parties' agreement with you to rule something differently? The arbitrator made that legal determination and said Mr. Durfee did not have that power. And Judge Bean, you'd recognize, the status of the law in Arizona when it comes to reviewing confirmed arbitration awards. Arbitration awards are deemed to be final and binding both as to questions of law and fact. Thank you very much, Your Honors.
Thank you.
Let me raise just a few points here. There's been a lot of discussion about Mr. Durfee benefiting his quote-unquote former client. We've outlined that in his...
Is that true?
It is not true.
He wasn't the former client of Mr.?
He never represented Mr. Hubbard in his individual capacity. He represented the trust and Mr. Hubbard as the trustee of the trust, but never represented Mr. Hubbard. Regarding, and those are different roles with different responsibilities, and I can assure you Mr. Durfee is not here to try to benefit Mr. Hubbard. He's here because of the responsibilities that he has as a trust protector to make sure that Grace's intent is followed. Then there's a discussion of Section 10-105, or Section 14-10105. It talks about different issues that are reserved to the court there. But again, we've got to look at what did the trust say? What does the trust do, and what rights was the trust protector given there? The fact that Mr. Lassiter chose to ignore the specific language and unambiguous language of the trust and disregard the binding interpretation is key. He can't come back and undo that. And frankly, that's why you have authority to come in and fix what Mr. Lassiter messed up.
What under the Revised Uniform Arbitration Act allows us to do that? Which statute allows us to undo a legal ruling by an arbitrator?
Well, it's those are issues Mr. Weech addressed more, but when the arbitrator goes outside of his grant of authority, and when he ignores the binding interpretation, which in words of one syllable is stated to be a binding interpretation and required to be a binding interpretation, he is acting outside of his grant of authority. He cannot do that. There's been some discussion here that Mr. Durfee changed everything after confirmation. He did not. The amendment to the trust was done after Mr. Lassiter issued his preliminary decision, before he issued the final.
January and February of that year.
Yes. And so that was done beforehand, and it didn't get to confirmation till much later. In fact, we didn't have a final judgment until just a few months ago. It took quite a while for all that to unwind. I'm out of time. I'd ask you to rule that that Grace granted Mr. Durfee the authority to review review the decision of the arbitrator. I'd ask you to vacate the Lassiter Award in order that the Ratz Award be affirmed.
Thank you.
Thank you.
Thank you to all the lawyers for your briefs and your argument. We'll take the matter under advisement and issue a decision in due course. We will stand in recess to allow the next group to set up. Thank you.